Hi, my name is Norvell Gaddison, and this is for my criminal procedures class. The case I chose was Terry versus Ohio. It's a stop and frisk case. Terry was convicted of carrying a weapon and sentenced to the statutory prescribed term of 1 to 3 years in the penitentiary. This was a Fourth Amendment case appealed to the U.S. Supreme Court for violations of the Fourth Amendment unreasonable search and seizure. The facts of the case is Terry and two men was observed by a plainclothes policeman in what the officer believed to be they were casing a job or getting ready to perform a stick up. The officer stopped and frisked the three and found a weapon on two of them. During the pretrial hearing, the defense moved to suppress the weapon based on unreasonable search and seizure. The trial court rejected the prosecution's theory that the gun had been seized during a search incident to lawful arrest. The court denied the motion to suppress and admitted the weapon into evidence on the grounds that the officer had cause to believe that the three were acting suspiciously and that their interrogation was warranted, and that the officer for his own protection had the right to pat down the outer clothing, having reasonable cause to believe they might be armed. This case was considered under the Fourth Amendment because it was dealing with unreasonable search and seizure of a weapon. The Fourth Amendment was introduced based on the unreasonable search of Terry and two other men and seizure of two weapons. The defense claimed the petitioner rights were violated. The court, however, distinguishes an investigatory stop and an arrest between a frisk and of the outer clothing for a weapon and a full-blown search for evidence of a crime. The petitioner and Clinton were found guilty, and an intermediate appellate court affirmed, and the state Supreme Court dismissed the appeal on the grounds that no substantial constitutional question was involved. However, the U.S. Supreme Court, the court held that the Fourth Amendment right against unreasonable search and seizure made applicable to the states by the 14th Amendment protects people, not places, and therefore applies as much to a citizen on the street as well as at home or elsewhere. This was dealing with the exclusionary rule. The issue in this case is not the abstract of the police conduct, but the admissibility against petitioner of the evidence uncovered by the search and seizure. The exclusionary rule didn't apply in this case to exclude the evidence of a legitimate and restrained police investigative technique. And the court approved of such techniques and does not discourage remedies other than the exclusionary rule to curtail police abuse for which it is not an effective sanction. When a reasonably prudent officer is warranted in circumstances of a given case in believing that his safety or that of others is endangered, he may make a reasonable search for weapons of the person believed by him to be armed and dangerous, regardless of whether he has probable cause to arrest that individual for a crime or the absolute certainty that that individual is armed. The officer here was performing a legitimate function of investigating suspicious conduct when he decided to approach the petitioner and his companions. The officer's protective seizure of petitioner and his companions and the limited search which he made were reasonable both at their inception and as conducted. The action of the petitioner and his companions were consistent with the hypothesis that they were contemplating a daylight robbery and were armed. The revolver seized from the petitioner was properly admitted into evidence against him, since the search which led to his seizure was reasonable under the Fourth Amendment. The conviction was affirmed. The effects this case had on law enforcement was minimal at best. The court ruled that the search and seizure was legal, therefore there was no effect on law enforcement. Had the decision been reversed, then the effects would not only allow police to stop and frisk or even stop to question suspicious activity. The effects it had on society is it proved better service. It provided better service by the police in preventing crimes in the community. In my opinion, the court ruling was correct and the evidence should have been admitted. The officer was acting in the line of duty.